It was a day of hypothetical scenarios and idealistic examples of how a public protector should operate, as both legal teams pursued the impact of personal cost orders against a public protector.
Nobody would ever want to be a public protector because he says it should be just to bankrupt the person, basically.
It should be directed at the institution, not at the person, because we are all human. You know, we do make mistakes in our jobs.
Mpofu also argued that the suspension and removal of a public protector must be similar to that of a judge. He further argued that even judges were not removed from office if their judgments were successfully challenged. The evidence leader also picked up on the theme of personal cost orders against the public protector.
Public protector's entire model of investigation was flawed. She was not honest about her engagements during the investigation. In addition, she failed to engage with the parties directly affected by a new remedial action before she published the final report. This type of conduct falls far short of the high standards required of her office. Now, that's a finding of dishonesty.
My emphasis was just on the award of 15% of personal costs.
Another recurring theme was whether it was wise for Mkhwebane to recommend constitutional amendments like the nationalization of the Reserve Bank, which was dismissed by the Constitutional Court.
Public Protector issued a final report in circumstances where the Reserve Bank had specifically asked for an opportunity to look at the report to ensure that there wasn't harm to the economy. That was not adhered to, and the report was not provided to the Reserve Bank. This resulted in a significant depreciation in the rand and the sell-off by non-resident investors of 1.3 billion rand worth of South African government bonds.
I'd say that in some jurisdictions, especially in Europe, the ombudspersons do make recommendations for the changes of laws. I think you saw it under the Venice Principles.
That's correct.
So it was in that regard that I answered in the affirmative.
The evidence leader and Mkhwebane's counsel appeared not to find each other at times as they differed on what questions and evidence is relevant to the committee. The inquiry continues on Wednesday. Tulelani Philip, SABC News, Parliament.